Happy Friday. I'm Nancy Levesque, Communications Director for the Future of Privacy Forum. Welcome to this week's Privacy Chat. Today we're talking about opting in versus opting out. Should consumers have opt-in rights for data collection, or is opt-out the way to go? Joining us today is Justin Brookman, Director of Consumer Privacy and Technology Policy at Consumer Reports, and FPF's very own Stacey Gray, Senior Counsel. With that, I'll hand it over to our CEO, Jules Polonetsky. Take it away, Jules.
Thanks, Nancy, and thanks, Justin and Stacey for joining me. Hey, nice to see you guys. This is the only way we see each other nowadays, so this is how it will be. Thanks for everybody who's joined us on the last couple of Fridays, and I think we're going to keep it going because we've had some really great and useful discussions. Many of you saw a New York Times article in an opinion piece, the lead editorial, thanks to the team here for popping it in front of us, by one of their lead writers, telling America, your privacy settings are wrong. Apologies to our global or European friends. I think this article definitely took a very US approach, although it referred to GDPR as a model for the opt-in path that it called, which gets some of us privacy geeks a little crazy because by no means is the GDPR an opt-in model. Of course, there's a lot of opting in people seem to be doing because of the related e-privacy law that requires consents for cookies. And yes, it is true that consent, as defined in the GDPR, is a very significant option, and one that sometimes regulators or critics default to, saying use that because if you don't consent, then things won't happen. So they'll think about it as opt-in. But the Europeans have defined consent with a lot more nuance, and maybe there's some lessons that we might learn. In any event, we are in a legislative mode here in the US. As we all know, states are passing laws. Two people quite active, both in the state level discussions and the federal discussions, are the two folks who've joined me here. Stacey, who works on a lot of our federal and state legislation and has been active in the states, and Justin Brookman, whose long career today at Consumer Reports, but previously at places like the FTC, the New York State Attorney's General Office, where I think I first met him, many years at the Center for Democracy and Technology, a stint at the FTC. So folks who've seen a lot of the pieces, and great to have this chat with. So let me start with Justin. I think partly as a reaction to some of this opt-in, opt-out, that's the way to do legislation, Consumer Reports has a model state bill that has far more nuance and really tries to avoid some of these critiques of consent fatigue and the other issues that people complain about. And even at the federal level, there's a Senate proposal by Senator Sherrod Brown. I don't remember whether CR has supported that or how you guys have talked about it, but it also purports to be a not about opting in or out. So what was your reaction when you saw the New York Times piece? Did your head kind of explode like mine did?
I mean, it felt a little dated, like the kind of like the advocate's position from maybe like 5 years ago, where you generally see complaints around opt-out models. They're not workable, and we are seeing that in California. I mean, it seems kind of silly, the idea that you should scroll to the bottom of each page, click opt-out, selling your information. We've done some studies showing it's just not workable, and so the default for advocates was always like, well, opt-in, like get your permission. But I think we're seeing, whether GDPR is consent-based or not, you're definitely seeing consent-y things in GDPR. And do you really want a scenario where you get a cookie screen every time you go to a website and you have to click OK just to proceed? People don't really know what's going on. Similarly, do you have to click, I agree to this privacy policy when no one's going to read it or know what's in there? Is that really consent, right? And so, you don't want to stop people from volitionally sharing data, but you also don't want these kind of fake consent-y things, which do not usually really reflect. The approach we try to take in the bill is to say that, data processing that's reasonably necessary for what the consumer is asking for, right? So framing it in terms of the volition of the consumer, like that's allowed, that's cool. You don't need to click OK for consent for that. Even if it's sensitive, just should happen. Even if it's sharing, like whatever, like, you know, Amazon's got to share my data with UPS, like don't make me click OK to that. So that like should happen by default. And maybe if it's like a little bit confusing or not intuitive, they should maybe say a little bit about it to inform consumers. But like the goal is to like not put a lot of cognitive burden on people. But the flip side is that like all the other stuff just doesn't happen, right? You can't bombard the user for a request to share with marketers or to share for secondary purposes. Certain purposes are allowed and carved out, and like analytics and some first-party advertising and things that you kind of need to have the ships run. But otherwise, just not throw all this, again, whether it's opting out or opting in, all this burden on consumers, and just have that conform data flows to like what a person would reasonably expect. I mean, again, people can always opt. Companies will always be aggressive and try to push folks into agreeing to more. So, you know, we try to deal with that through things like, you know, you can't use dark patterns. Dark patterns are already probably illegal under UDAP law, but I think calling it out might be helpful. And then I guess the other piece is non-discrimination. You can't treat someone worse if they don't agree to secondary data collection, which is something that's a little bit in CCPA. But then they say, well, not really. It's a little bit better in the Washington State bill. And so again, like I don't. This has been the reflection of a bunch of years of discussions with advocates and industry folks as well to try to find the right balance. And again, yeah, we shared that approach with Senator Brown's office and also Senator Buffy Wicks in California, who introduced a similar approach as well. But it's also like, I don't know, it took us a while to actually publish it out loud, because it is hard to know if you're finding the right balance or not.
Stacey, you obviously spoke to the editorial writer and probably and quoted in the piece. So congrats. But what nuance would you wish perhaps that was further expressed in that piece? And I know when you talk to state legislators, they default to this. Oh, are you for opt-in or opt-out? We heard that the advocates are for opt-in and the industry is for opt-out. What are you for? And it seems like it's really hard to bring people to that more nuanced thinking that it's actually not all about this sort of binary good, bad, in, out.
Yeah. So one of the things we talked a lot about was the sort of benefits and drawbacks of both opt-in and opt-out, and then sort of getting us to a point where we can move beyond that to talk about what else there is. And this is the way in which I think the Consumer Reports Model Bill is going to be very effective and is really contributing to this debate by avoiding opt-in and opt-out altogether and showing that there can be privacy protections that don't rely on either. That said, I mean, I think we're big fans of opt-in when it's meaningful and in the context where it can be meaningful, right? And so that means you have to think critically about, is this something that your average user really can be informed about? For a lot of secondary uses and a lot of really complex technology, it's not something where we can reasonably expect average people to make informed decisions. And also useful, I think, to think about opt-in consent in the context of what business practices and data flows it would effectively halt, and when is that a good thing and when is that a not desirable thing. So a good example of this, I think, is anything in the realm of public space tracking. So facial recognition, which I know, Justin, is something you've spent a lot of time on. That's not something that in most cases companies can get affirmative consent for. So placing an opt-in requirement around the use of sort of passive biometric data effectively stops it in a lot of cases. Not all. You might have some, customer loyalty program at a retail store, for instance, but effectively stops a lot of the practices that people are concerned about. In other cases, opt-in consent stops practices that we don't necessarily want to stop, right? So we've talked about this a lot in the context of commercial research. So today, many academics who are interested interested in conducting research or getting a lot of their data, sometimes very sensitive data, from private companies, like your, not to name specific companies, but like your Fitbits and your Apple Watches and your sort of wearable devices, and companies that are collecting really interesting, useful data that might be used for health breakthroughs or research into mental health. And the appropriate safeguards around that kind of use of data are very important, but they probably shouldn't rest just on consent, because we know we get biased outcomes in who says yes and who says no. Probably the appropriate safeguards should be to effectively pseudonymize data, to not use it for secondary purposes, to not use it for some purposes at all, to make sure that there's independent oversight. If there's a commercial advantage to the company collecting it, to make sure that's not the only reason the data is being used. So we've talked a lot about ethical review boards being a potential model for this. You know, we're very used to IRBs in the academic space. You can imagine commercial IRB-like entities. I don't know. I could go on and on, Jules.
Well, you know how I thought about it a number of years ago. Omer Tinay and I wrote a piece called like "To Track or Not to Track." That is the question, and
Right.
we basically were saying, look, here's the reason why do not track efforts and other things never end up being resolved. People are debating is the notice good enough? Is the opt-in or opt-out good enough? And my argument is zero ability that anybody would agree if they disagreed about whether it's a good thing or it's a bad thing. If you think, I don't know, internet advertising is the best thing since apple pie, and that it keeps the internet free and is a goodly thing in the world, then I don't care whether you call it opt-in or opt-out. If at the end of the day, most people are not gonna be in it, then you're against it. You don't really care. You give me an easy opt-in somehow, like click here and your life will be better, so everyone clicks, then they're for opt-in, right? Or opt-out. And if you're somebody coming from the point of view is this is the most Orwellian thing that really risks everybody's rights, then you really aren't going to care what it looks like. All I know is that if somehow, whether you call it in or out, most people are somehow in it, and you think this is actually a bad thing for society, then you are unhappy. And opt-in and opt-out are just the easy ways to say, should the switch be default on or switch be off? Hey, if the switch is off, but it's dark and everybody has to turn it on, that's fine too, right? I mean, so don't we first have to say, what are the things that we all agree, you know, not that are bad and illegal, right? Because those clearly ought to be very hard or very, you know, really risky to do. But it feels like there's a few things, the advertising, selling, right? That's one of the things that people sort of generally think maybe that ought not to be happening by default. Some think, well, but it helps support competition or blah, blah, blah. And others think, sorry, you're selling data, right? So you can see why there's maybe different views sort of on that. But it feels like there's a bunch of stuff in the middle that, you know, or things that we don't even know about yet that are possible features or uses. And the debate really, I think, is how do you deal with those? So maybe what you learned from GDPR, right, is GDPR with its legitimate interest model says, well, if you have a legitimate reason to be doing this, and you actually do a balancing test and so forth, and you determine whether you got it, but we're really trusting the company at the end of the day, and the privacy officer, who in theory has some DPO obligation to also be, you know, honest with the data authorities and that sort of thing, and be a bit independent to sort of do this assessment. And on the US side, the notion of, you know, privacy impact assessments or review committees, you see people saying, certainly on civil society side, saying, huh, that'll be a rubber stamp. I'm not going to trust you. So Justin, how does the CR bill deal with things like, I don't know, product improvement? That could be a really nice thing, make my product work better. It could also mean, I don't know, maybe a giant hole that people drive things through. How do you deal with the, you know, some people say, well, the FTC will make rules. How do you think about that sort of?
Yeah, I mean, I definitely I'm not personally a fan of the IRB approach or the let's hire Hogan levels to document write a 10-page or 100-page report about why this is totally fine. No offense, like they're great lawyers, but I mean I think it will tend to err on the side of what the company itself wants to do. So I don't want to put too much. I don't like the legitimate interest approach. I mean our approach again, it is fairly aggressive. Like I think like for is definitely carved out. It is, it has to be reasonable and proportionate to what, and then there's some balancing there, and that gives companies some wiggle room. But by and large, most sharing is going to be prohibited as inconsistent with contextual integrity. And I think Stacey raises a good example on research, and that's definitely one of the hardest areas. And I can see societal benefits to it. By the same token, because my Fitbit, and I don't necessarily want researchers at University of Iowa, which is a great institution, like knowing what I do with having unfiltered access to all the places that I go and whether I got my steps in or whatnot. I think that's my Fitbit, and so our bill would broadly prohibit that. There are exceptions for de-identified data. I think some privacy advocates are de-identified skeptical. I think it can be done in ways that you can get value from data, and I think we do try to carve out some sharing of data if it really is de-identified. It's not like a hashed UID, but if it isn't going to change the user experience and it is for research, de-identified data I think can be okay, as long as it meets like the FTC's test.
You mentioned dark patterns for a minute, and I can't resist sticking with you on that for a second, since your consumer protection background on this in particular. One of the things we are trying to figure out in some of our dark patterns work is this just a nice term to use to say we have consumer protection law? It actually talks about patterns that are deceptive or unfair or aren't comprehensive and so on and so forth. And hey, FTC, get with the game. So let's label it, or is there something new or more, right? I mean, if all we're doing is saying, do a better job at enforcing consumer protection law, because these things that we're seeing online really are illegal and ought to be the subject of enforcement, but nobody's amending the consumer protection law. We're like coming up with new things and we're putting them in privacy law and we're saying thou shalt not have a dark pattern. Is this a call to extend consumer protection law? Some people have said that the CFPB has this abusive language. So, is it possible that I meet the FTC standard? There's a disclosure, but I did so much research that I learned that if I make it light blue and I put it in the corner and I ask you twice, you'll probably give up. Or if I ask you 3 times, you'll probably give up. What's your take?
I think, but all of what you just said. I mean, I think you can make the case that UDAP, unfair and deceptive practices, was intended to be incredibly broad to apply to new areas, and I think you can make the case that all dark patterns are illegal. I think it's hard for the FTC to enforce that, right? And so they have to pay for user testing, and they have to it's a lot of work to actually prove that something is dark. And whereas the companies, because of what you said, because of potentially artificial intelligence and the ability to do countless A/B tests to see what people respond to and what they don't, have in a much more privileged position than the FTC to kind of tweak people. So I think that's right. I have thought about the idea of bringing over the idea of abusiveness in there to make it more explicit, that these interfaces can't subvert user intent. But I'm not sure that's enough, right? Because you still have the issues like how did the FTC enforce it? I think the other area, the other idea that might get to that, which I had traditionally not been sold on, but I'm coming around on, is the idea of fiduciary duty, or a duty to to act in the interests of consumers. And maybe if companies do have a good faith obligation to not try to mess with people or subvert intent, maybe that also goes some of the way to address some of the dark patterns.
Do we know the difference between trying to sell you and persuade you and deceive you, right? I mean, someone says, I don't want to renew, and you pop up a pretty please, I'll give you $1 discount, right? So I don't know, that's going to dissuade some people. and some people might be confused, and others are just like, okay, whatever. Where, subliminal advertising, deceptive, but it seems like some of the critiques, have been sort of like, and I think the Europeans have been introducing, a very different framing around this, that it's got to be your free will. It's got to be, and it feels like that almost says, no, you can't advertise me. This is an ethical decision. You're going to donate your kidney. You're going to have a medical procedure. You're going to donate your data for research. Nobody should be like trying to sell you here, right? It's got to be an honest decision. That seems to say that don't be, right? So it's one thing to say don't be twisting the consumer's arm, but where's the line between what might be protected, kind of persuading, begging, pleading? I mean, I don't know. Stacey, what's your...
I mean, I think consumer protection law is maybe more powerful than we're giving it credit, and common law tort on some of these issues. But it's really hard, and this is part of why I'm skeptical personally still about the fiduciary model, because it seems that there is an existing responsibility to make a business profitable, right? And if that involves monetizing data, then there's a little bit of a disconnect there. And how do you reconcile that with trying to persuade people and trying to get them to share data? I kind of want to circle back, though, a little bit to legitimate interests, though, Justin, and give a shout out to my colleague, Dr. Gabriela Zanfierce-Fortuna, who published this amazing report a couple of years ago, compiling all of the instances in which data protection authorities in the EU have applied this legal test effectively, and looking at some of that case law essentially in the EU. Because I think it gets a little bit of a bad rap, right? I think some companies that aren't used to it don't necessarily like it because it doesn't feel clear. Advocates don't like it because they think it's going to be a loophole for companies to do whatever they want with a rubber stamp. But it's actually quite a strong test, and we've got a link in the chat now too. That's awesome. It can be a strong test if enforced, and I think of it as one tool in the arsenal of collection limits. OptIn is another tool in collection, limiting collection. We know it doesn't work for everything. We know it requires information, and a reasonable person to be able to make a choice. Doesn't work in screenless, doesn't work with emerging technologies like connected cars, right? So other tools, legitimate interests, contract, data minimization, purpose limitation, these are all really, really powerful. And the case that I always think of, I'm not going to remember which nation it was in the EU, but there was a case involving automatic license plate reader technology and a gas station that was using license plate reader technology to identify people that were driving up, filling their car up with gas and then not paying and driving away. In order for that kind of data processing, which can't be done with consent, to be clear, to be legitimate, it had to be necessary to a legitimate purpose and not outweighed by impact to the rights and freedoms of the data subject. And the court in that case said, fine, this is a legitimate interest. Okay, fraud, right? Making money. This is legitimate business interest, but it's not necessary because you have an alternative. And your alternative is just to ask people to pay up front. You don't need the data at all, right? There's an alternative. It's not necessary. And even if it were, it would potentially be outweighed by the impact on the rights and freedoms of the data subject.
So who's going to determine, we've had decades of things like what is reasonable under US law. And, at the end of the day, we use those terms and the courts and everyone else figures out what it means. Here we're going to be we have already introduced in California, Washington, California, Virginia, terms like minimization and, who assesses that balance? I mean, let's take a look at the surveillance world, right? The Schrems court said what the US does is not reasonable and proportionate. You're collecting way too much. It doesn't belong in democratic society, right? And our Congress and our courts, and certainly our surveillance authorities have said, well, this is a pretty good balance. We're keeping the world safe. We're keeping Americans safe. We're keeping you Europeans safe by giving your authorities the data. And who's going to deter? So, there can be giant gaps in those terms. Are we going to be litigating, I don't know, data retention? How long, ed tech has said, here's how long we think data needs to be kept because we want to provide certain kinds of reporting. And if you limit it, then we can't do reporting over a certain amount of time. And a critic would be like, well, that seems obscene and that seems way too long. So how do you envision, I mean, again, is this going to be FTC rulemaking, or are we going to be litigating these terms in the courts for years? Or I don't know, Justin, is there more certainty on these terms than I imagine?
I mean, for reasonable and proportionate, which I think is another important idea. I mean, you could have FTC rulemaking. I think FTC should be empowered to do rulemaking. Right, we're seeing in Europe, like, where companies I think are maybe pushing the bounds of legitimate interest, and I think because you're not seeing the regulators willing to push back, then it means legitimate interest means what they they want it to mean. And I should read Gabriella's report, but I think back to like the ICO saying, yeah, all this real-time bidding, that's totally not legitimate interest. That totally should be illegal. Like, if only someone could do something about it. And so I think that's the question, like whether the regulators have the capacity again to bring these cases. It's something that we're seeing in the competition realm, right? Like that the FTC just doesn't have the ability to keep up with these cases. And do they have to spend 10 years in court trying to prove like the most fundamental facts, or is there a more streamlined process? And one idea I think about, which I've occasionally think about, is like whether like you need an ALJ at the FTC to kind of adjudicate some of these issues. Like there's one ALJ right now. So maybe it's like a lower stakes and easier process to kind of get a ruling on some of these things. It's one idea I've thought of, but I haven't really fleshed it out maybe as much as I should.
I find myself pointing to some of the aspects of GDPR more and more, and you don't always need to agree with where the European endgame came out, but the fact that there's a lot of nuance built in to each of those structures. You think you don't like consent? Well, take a look at how they're actually trying to, narrow the way consent is used. And you don't like legitimate interest? Well, take a look, as Gabriella points out, on, at least how heavy and structured a burden of balancing and assessing and opting out. We treat opt out almost as you didn't opt out, now life is screwed. You're stuck. I sold your data, bad things happen. And the whole notion of maybe I have the right to do this thing, but I actually need to let you object to it. Or maybe I don't, because it really is necessary. In an ideal world, it works quite nicely. Well, listen, for folks who want to underscore and understand the kinds of data flows we're talking about, at least when it comes to, say, ad tech, please join our training program so that you can understand what in the world is going on when people are debating this opt-in, opt-out, or the in-between thoughts around advertising. Justin mentioned some of the skepticism, but yet perhaps, hope that one could have serious de-identification. We have a deep dive into that. These are not law and policy classes. We assume you're all smart enough to suck up that information from all the material out there. These are understanding the tech and data flows in a balanced way so that you can actually then be a fierce expert in these debates and discussions. So take a look at fpf.org and hopefully sign up for some of the classes and courses. Justin, great to see you. Thanks for engaging with us on this. Look forward to the legislative discussions. I think the contribution that Consumer Reports has put on the table moves the debate forward, and I'm optimistic that we will sooner than later. Stacey, thanks so much for all the work you do debating this day by day, and thanks to everybody who joined us for this LinkedIn Live. We'll jump into some of the comments that we didn't get to bring on today, and hopefully you will have a great weekend. Bye, everybody. Thanks, Justin. Thanks, Stacey.